Thank you. Thank you.
Good afternoon. Welcome to all of you here at the College of Law and to everyone on the webinar. I am also thrilled to welcome our speaker who is on Zoom and our 4 speakers who drove from Phoenix to be here today. This is the 4th event this academic year of the Bacon Immigration Law and Policy Series. And we're very pleased that the Arizona chapter of the American Immigration Lawyers Association has made this event its CLE for the month. So welcome to all of our ALA colleagues as well. My name is Lynn Marcus, and I'm the director of the Community Immigration Law Placement Clinic and one of 3 co-directors of the Bacon Immigration Law and Policy Program at the James E. Rodriguez College of Law. And we want to start by expressing our heartfelt gratitude to Carol Lee Taylor. Did you leave her? Who's out of the room, but Carol Lee is a law clinic administrator who has become an expert at juggling just an absurd number of behind the scenes details to make events like this possible. So thank you to Carol Lee and also to Ricardo Ruiz and Tristan Caputo from IT who are helping us out today. We're going to start by hearing from 2 Arizona journalists, Terry Greene Sterling and Jude Joffe-Block. Terry is editor-at-large for the Arizona Center for Investigative Reporting and serves as affiliated faculty at the Walter Cronkite School of Journalism at ASU. And Jude has reported for the Associated Press, National Public Radio, The Guardian, and other outlets. Jude and Terry co-authored the book Driving While Brown, Sheriff Joe Arpaio versus the Latino Resistance, which we will be hearing about. NPR named the book one of the 2021 books we love. The Immigration Professor blog named it the Immigration Book of the Year for 2021. And the Phoenix New Times named it Best Nonfiction in its Best of Phoenix Awards. The book, as you'll see, dives into the lives and motivations and the characters and details of the critical cases and events in the history of Arizona's restrictionist movement and then the resistance that rose up against it. And we're very lucky that we'll get to hear more and insider details about the cases today from our panelists. After a slide presentation by Jude and Terry, we are going to hear from 3 panelists: immigrants' rights activist Lydia Guzman and immigration lawyers Delia Salvatierra and Johnny Sinitis. And each was deeply involved in the events that are portrayed in the book. And then Jude and Terry have questions for the panelists. And then after that, we'll have a question and answer session. Just a couple quick logistics. If you're a lawyer on the webinar and we'll be getting CLE credit, look for the certificate of attendance and link to the materials, which is the PowerPoint. That will be posted in the chat during the webinar. And then Elizabeth Hanna, who is co-president of the Immigration Law Students Association, has graciously agreed to moderate for the Q&A session, which will be from around 1 to 1:15 when our event ends. And Lizzie will monitor the chat and the questions from the audience here, and she'll read questions aloud for the panel and the speakers. So if you're here and you have a question, we have note cards, which we will distribute, and just put it on a note card and raise your hand, pass your note card to the end, and we'll collect it. And Lizzie will read out the question. So thank you so much to Terry and Jude and our panelists for taking the time to prepare for today's presentation and to be here today. And without further ado, Terry and Jude.
All right. Well, thank you so much, Lynn. Thank you, Carol Lee. Thank you all for coming and being here with us. And thank you for wearing your masks, those of you in the room with us. Can I come up? Come up. And we'll be talking about our book, and these books are for sale outside. The University of Arizona Bookstore is here, and we would be more than thrilled to sign your copy if you're here in person. And if you are not, we still are very excited if you would like to buy the book. And so with that, we are going to get started with our presentation. This gentleman is blocked right now, for those of you in the room, please move that over. This is Danny Ortega, but back up why we're showing you this slide. To fully appreciate the conflict in this book, we felt it was important to situate it in the context of decades of race relations in Arizona, long before Joe Arpaio was sheriff, and his supporters and his opponents arrived on the scene. So there's a long history of people of Mexican descent in Arizona battling for their civil rights. Among other things, for a long time, those of Mexican descent have felt targeted by immigration-themed traffic stops long before Arpaio's tenure as sheriff. And Danny Ortega, who you see here, he's a Phoenix-based lawyer, eventually became part of the resistance against Arpaio, and we'll talk more about that in this talk. But long before that, he was a recent law school graduate in the 1970s, and he learned that, excuse me, that police in the Phoenix suburb of Peoria were targeting farm workers in traffic stops to check their papers. And Danny, as a US-born Mexican-American, realized that this kind of enforcement targeted people like him too. And let's take a listen to Danny's quote here.
People were being stopped because they were brown, driving while brown, okay? And so we saw this not only as an attack on the undocumented community, but we saw it as an attack on us, simply because of the features of our skin and our hair color and our language.
And we bring up this incident because it spawned a key lawsuit. Farm workers in Peoria sued over these immigration-themed traffic stops in 1978. They didn't win their case, but the Ninth Circuit in 1983 in their ruling did say that it was not the role of local police to enforce the civil provisions of federal immigration law, such as arresting an immigrant for not having legal status in the country. Rather, that was the purview of federal immigration officers rather than local police. And the precedent in that case would wind up being critical to some of the other legal battles that happened later. And in the course of this talk, we're going to be talking about 4 key lawsuits that were brought by people who were the most impacted. So that's the first.
Okay. Hello, everyone. I'm Terry. I wanted to talk to you, fast forward to the mid-2000s. One local sheriff in Arizona, known throughout the world, Sheriff Joe Arpaio, Maricopa County, starts raiding work sites to arrest immigrant workers. And he also engages in immigration-themed traffic stops. So many Latino drivers and passengers feel targeted, as well as the immigrant workers. Because Arpaio is known to retaliate quite severely against his critics, the power broker structure in Maricopa County does not stand up to him. And it takes a fearless Latino resistance, well-coordinated resistance, to stand up to Arpaio, as well as to the laws that are being passed in the Arizona legislature that he supports. So who is it? Wait a minute, I think I got my slides mixed up. Okay, okay, right. Okay, so we've done this slideshow a lot. We keep turning the slides around, some of the lost. Okay, so who is Joe Arpaio? Joe Arpaio was born in Massachusetts as a child of an unwanted Italian immigrant during the time when the eugenics movement had a great influence on immigration laws and Italians were considered not desirable. He is taunted, he is teased, and he ends up going into the DEA, or the precursor for the DEA, and having a career in drug enforcement. But the little boy that was taunted and teased, after he retires from drug enforcement, He runs for sheriff in 1992. And a few years after that, during his tenure for sheriff, he becomes the tormentor, the bane of unwanted immigrants. In 1992, when he's elected, he serves route food in his jails, makes inmates sleep in Korean war tents, and makes inmates wear humiliating pink underwear. You have all probably heard of that, some of you who are older. And the net effect is that Joe Arpaio creates a persona for himself as America's toughest sheriff. So in the early 2000s, a movement builds in Arizona to restrict immigration from Central America and Mexico. Arpaio pivots to immigration enforcement in about 2006 after it becomes popular with his base. So he keeps the pink underwear and the Korean war tents, but then he adds immigration to his portfolio, law enforcement portfolio.
And in 2006, a very important new state law takes effect. And the intent from the Arizona legislature with this law, which was called the Arizona Human Smuggling Law, as written, it was an effort to punish smugglers who brought migrants into Arizona and punish them with a state charge, a state felony charge. Arpaio, as sort of his first move as pivoting towards an immigration enforcer, partners with the county attorney at the time, Andrew Thomas, who later disbarred, to interpret this law to mean that they can also arrest the migrants on conspiracy to smuggle themselves. And so suddenly migrants in Maricopa County become felons. And this is part of a pattern that we'll see and talk about, this strategy to basically criminalize the undocumented and put them in jail and then basically ensure their deportation. So this is an article from La Voz, the Spanish language newspaper at the time, and it's the headline from the first group of migrants who were arrested using this conspiracy charge that Thomas and Arpaio came up with. Okay. And I also want to note that at the time, Arizona voters had approved a law that said that undocumented people, when arrested on certain crimes, could not get bond. So people, this group of individuals would not be eligible to be released from jail before their trials. So that's another key element of what's going on. And so as part of Arpaio's ramp up in immigration enforcement, he signs up for a federal partnership to enforce immigration laws. And that partnership is known as 287G. And in the past, only federal agents, not local police, could arrest immigrants solely for being in the country without legal immigration status, since being undocumented is a civil violation, not a crime. And remember, that was part of what the Ninth Circuit was alluding to in that 1983 ruling. But Arpaio makes clear when he's using this new 287G partnership that he plans to arrest immigrants who are in the country without papers, regardless if they've committed a crime. And this is from a press conference he gave at the time.
My program, my philosophy is pure program. You go after illegals, you're not afraid to say that. And you go after them and you lock them up.
And another key part of the strategy are these worksite raids. This is a photo of one at a car wash, and workers are arrested on felony charges for forgery and identity theft. And so again, this is part of the pattern of undocumented workers suddenly become reimagined as felons. And we're going to discuss these worksite raids with our panel and talk more about it. And then another part of the strategy were neighborhood sweeps. So Arpaio's deputies would pull over cars for minor traffic violations like cracked windshield, broken taillight, Suspected undocumented immigrants were turned over to ICE, and Latino drivers and passengers felt like they too were being targeted. And we're going to show you a scene from the documentary film Two Americans, which we highly recommend. And it shows footage from some of these neighborhood sweeps, including in these scenes, you're going to see activists who rush to try and protest and help the people who are being arrested and tell them about their rights.
Stories. Stories. I was at speed. I didn't do any relation. I think it's the way to look. And look at it.
Okay, many of the people in the book are members of the resistance, and it's important to note who joins this resistance, which is so well coordinated and so effective. Members of indigenous communities join, day laborers, immigrant day laborers join, Mexican Americans, older Chicanos, immigrants and their children, young Latinx activists, and of course, allies. And I'd like to introduce you to a main figure in our book who is with us today. Whoops, I was just pounding my heart and I hit the mic, Lydia. Sorry about that. This is Lydia Guzman. She does many things in the resistance and pays many personal costs, which you can read about in the book. One of the many contributions that Lydia makes is finding plaintiffs for different lawsuits. And the lawsuits, of course, are to fight unconstitutional policing.
And I mentioned at the beginning that we were going to talk about 4 key lawsuits today. And I think Lydia played a role in all 3 of these. And so the first was a case where the migrants were being charged with conspiracy for smuggling themselves into Arizona. They sued and with the help of some organizations, and that policy was eventually struck down. It took a long time. That suit was filed in 2006, struck down in 2013. Melendrez v. Arpaio is the main case that we talk about in the book, which is Latino motorists sued Arpaio over his immigration-themed traffic stops, accused the sheriff of racial profiling, and that case we'll talk more about. And Puente v. Arpaio, filed in 2014, immigrant workers who were arrested in the worksite raids sued over those. And so we'll talk about all of these. And then another key piece of litigation that we should mention is that in the backdrop of all of this, of course, is Senate Bill 1070, which, in case you haven't heard of, was a omnibus immigration bill passed by the Arizona legislature in 2010. And it created new state crimes that unauthorized immigrants and legal immigrants could be prosecuted for, as well as the people who harbored or hired them. Section 2B of the law is sort of known, probably the most famous section. It required law enforcement, while enforcing other laws, to check immigration status of those they stopped, detained, or arrested if they had reasonable suspicion that they were in the country unlawfully. And there were immediate challenges to SB 1070. Critics and members of the Latino resistance worried that it would encourage all Arizona police departments to use similar tactics to what Arpaio's sheriff's office was doing. And as a result of the legal challenges, the US Supreme Court struck down several portions in 2012. And then as a different case against the law moved forward, eventually reached a settlement in 2016 that modified how the Supreme Court had let Section 2B stand, the part about the police questioning people about immigration status. There's now a settlement on the books with the Attorney General about how that section can be enforced. We're going to talk with the panel today about what that actually means for folks in Arizona today in 2022. So that's just some background. But we're going to, oh, sorry, I missed this slide, but too late. So our book focuses on the Melendrez lawsuit, as I mentioned, and it went to trial in 2012. That's actually where Terry and I first met, in the courtroom, covering that trial. And Arpaio, who for years had presented himself as the figurehead for the agency, now on the stand, distanced himself from the specifics of day-to-day operations and said he delegated them to others in his agency, and he denied any wrongdoing, and he condemned racial profiling. But a federal judge eventually found in 2013 that Arpaio's immigration enforcement tactics were unconstitutional. He ordered sweeping reforms to prevent racial profiling. And at this point, actually by 2010 or 2011-ish, Arpaio no longer had that 287G authority that we talked about, that you saw him in the video boasting about. Because that had been revoked by the Obama administration, the judge in this case pointed out that Arpaio did not have the authority to arrest immigrants who were not suspected of committing crimes. That he couldn't make arrests solely on the basis of suspected undocumented immigration status. And he forbid those immigration arrests as early as 2011. And it came out later that Arpaio's office had ignored those orders. And as a result, there was a contempt of court case against Arpaio, and people in the Latino resistance wanted Arpaio to be punished criminally for this as well. And this is in 2016. And you're going to hear from Viridiana Hernandez, a dreamer who was active in the movement.
Arpaio, he has done enough crime, he has done enough suffering, he has done enough pain, and our community will not take it anymore.
Okay, well, here we are, Donald Trump. In the 2016 presidential race, Arpaio supports Trump very early, lends his support to him. And we write in the book about Arpaio's devotion to Trump, and Trump gives him a payback for that, which we'll talk about in a second. But you know, for the activists on the ground in Arizona who have been fighting Arpaio for so many years and who understand the nuances of his personality, the activists note a great similarity between Donald Trump's persona and Joe Arpaio's persona, and many of the activists began calling Donald Trump the national Arpaio.
And in 2016, the same year, Yeah. So many of the activists who've been battling Arpaio for years launched a campaign called Basta Arpaio to get him out of office. And they mobilized voters of color who did not have a history of voting.
Okay, well, look what happens. All the struggle, all the walking on the streets, all the sacrifice, and all the risk has fruition. Joe Arpaio, after 24 years in office, loses the 2016 election. And after a criminal trial in which Arpaio is found to have engaged in criminal contempt of court, there is, there's talk on the street and there's a possibility, the remote possibility that this old man might have to spend some time in jail. But we write about the inside story of how this happens in the book as well. Arpaio, I'll let you read the book to find out why, but Arpaio gets a pardon from Donald Trump, from his friend Donald Trump, and that's possibly the payback for the early support. So he isn't sentenced. Trump pardons Arpaio before the sentencing.
And Arpaio tries to run for office again, but he's not successful in Republican primaries. And the grassroots efforts to mobilize voters of color in Arizona continues and shows its might in 2020. This is Maria Castro pictured here. She's a young activist who first started knocking on doors in Maricopa County to mobilize voters in 2011 when she was a high school student. And in 2020, she did the same. She told us that year she'd never seen the electorate as excited to vote. And Arizona, of course, went blue and voted for Biden for the first time in decades. And Maria told us that she thought that voters seeing that Arpaio could be taken out of office and that their vote mattered inspired more engagement in the 2020 election. Meanwhile, Paul Penzone is the Democrat who defeated Joe Arpaio in 2016. He won re-election in 2020. He dismantled Tent City and promised to reform the agency. At the same time, we wanted to note that immigrants who are arrested and booked into his jails still are routinely turned over to ICE for deportation. And the fact that that connection exists has disappointed some of the activists who worked to get him into office and continues to be sort of a point of protest. And I'm going to just put up briefly this cheat sheet of all the legal cases we talked about today, but we're going to take this slide down so that we can bring Lydia back up in a big view. Let me see if I know how to do that. Maybe someone else does in the room. Let's see. Oh, good idea.
There she is.
Let's try that. Get partly that. Well. Hi there, Lydia. So we're going to move to our panel now. If I just don't quite know how to make her bigger.
Wow.
Oh, okay. Thank you.
It's me.
Okay, perfect. Okay, great. There we go. Okay, we're all set. So thank you guys for bearing with us for that. And we're gonna just introduce our panel quickly and then start asking them questions and get your questions ready. We'll transition at the hour to audience questions. This is Lydia Guzman on the stage. On the screen, we talked about her in this presentation, but she's currently the Director of Advocacy and Civic Engagement for Chicanos por la Causa. She's a longtime Maricopa County activist who helped gather evidence for various lawsuits, including the racial profiling case against Arpaio, now known as Melendrez v. Penzone.
Hi again, Lydia. And I'd like to, it's such a great pleasure to introduce you to Delia Sabatera, an immigration and criminal defense attorney in Phoenix, who helped the Department of Justice coordinate interviews of non-citizens who had been transferred to ICE custody during Arpaio's immigration sweeps. She also helped secure the release of non-citizens who had been convicted of identity theft following illegal investigations orchestrated by Arpaio's Criminal Employment Squad. Thank you for your work, Jude.
And Cecilia's right is Johnny Sinodas. Did I get that last name correct? Okay, perfect. Is an attorney at Vanderhout LLP. His practice focuses on removal defense, the immigration consequences of criminal convictions, and federal court litigation. Previously at Salvatierra Law Group in Phoenix while working with Delia, he regularly represented non-citizens and undocumented workers who were victims of racially discriminatory policing practices in Maricopa County. Well, great. Thank you guys for being here. Thank you for having us. So we're going to start with you, Lydia. So you were involved in trying to find evidence and plaintiffs in several of the lawsuits we talked about today. And you also shared evidence with the FBI as part of an effort to get the Department of Justice to start its investigation of Arpaio and his office. And let's talk about the Melendrez case first. How did you go about finding people to participate in that case, the racial profiling case? And what issues did you run into trying to convince people to participate?
Sure. Well, thank you for that question. When Arpaio first started his immigration sweeps, this was a matter of lots of politics and politicking. And Arpaio had a campaign where he had on his vehicles a big sign that said report illegal immigration, and he had a hotline number. And we started our own hotline number. We started a hotline number because we knew that there were a package of immigration bills that were coming on the horizon that were going to attack immigrants. And they had already started with LAWA, the Legal Arizona Workers Act. And so we started this hotline to collect information to see how we can help and perhaps build a case. Now, as we started collecting information, we first started for the LAWA case. That's when we realized that we had a bigger problem and people were being stopped and they were being asked for their immigration status. And the people that were being stopped, they were telling us stories about how they were being questioned. They were being, many were citizens. They were just brown. They looked like me. They spoke like me. Maybe they listened to some of the same, Mexican music as I do. And so as we started collecting this information, we realized, this is something big, and this is something that, we started asking people to become plaintiffs. Now, that was hard because not everybody wanted to. There was a sense of intimidation that was taking place. But I think in the challenge was asking them to become plaintiffs. There was a lot of misconception and misinformation out there. That only, if they were deported, they became a plaintiff, and that just simply wasn't the case. A good plaintiff is someone who is a US citizen who was stopped and were suspected of not having authorization to be in this country, the whole racial profiling. And I think it became a matter of trying to educate the public of what racial profiling really is and how someone that looks like me or you or any Latino could actually be a victim of racial profiling. And that in itself, just talking about, I think many activists were on TV talking about the constitutional violation and how that was wrong. And I think that led more people to nod and say, okay, if this happened to me, I'll participate in this lawsuit.
Thank you for that.
Lydia, one more question for you. Because Arpaio's worksite raids will long be a focus of our panel discussion, tell us a little bit about him. You attended many of these worksite raids in person. I saw you there because I attended them too. Tell us how you would find out about the raids, how you would be alerted to them, what you would see when you arrived on the scene, and what you would do once you were there.
So notification of the raids came in two different forms. Because we did have the hotline, a lot of people had the hotline at their fingertips. They had it at their speed dial. And so we were immediately notified by people that actually worked in these facilities. It was amazing. I remember in one of the raids, there was someone who was calling us and texting us because they were on the roof of one of the companies that was being raided. Another gentleman was inside of a water tank of a car wash. As we were trying to talk to him, while there was a worksite raid taking place. And Arpaio himself sent out press releases to the media because he wanted the media to document this. But one of the key things, and I think that was really successful in this movement, was having a special relationship with members of the media, because I think when I spoke earlier about educating the community, we do a lot of this through earned media. We don't have money to launch a campaign or put fires out or robocalls or whatever. We actually use the media to help put out information. So we had a special relationship with the media. Now, as the media received word, sometimes I'd get word from the media that a worksite raid was about to take place. And this was just the special relationships that I had with members of the media. And in exchange, they would get to hear some of the stories. They would have exclusive interviews with maybe some of the families or someone that was left behind. And a lot of this helped to shape the narrative of the discussion of the carnage that was left behind after these worksite raids. But these worksite raids, really, if you look at the way that they were executed, this was a law that Arpaio was trying to enforce. But if you look at all 15 counties, only in Maricopa County was he doing it in this way, where he would go into a work site. I remember at a candle factory, I spoke with a lady who was absolutely mortified. She was yelled at. She was, she thought that the dogs were going to bite her. She explained how they separated the folks, all of the dark skinned folks down here and all the white folks stand over here. It was humiliating. It was dehumanizing. And that was part of the way that these worksite raids were executed. It was a total violation of your constitutional rights. But again, this is where, in talking to these folks, how we're able to gather this type of information to share with the lawyers that put forward these lawsuits.
Now let's turn to Johnny and Delia, because you two were practicing immigration law in Phoenix and you started having immigrant clients who were caught up in these worksite raids. And after they were being arrested, they were held in Arpaio's jails. And so as attorneys, what were you able to do for these incarcerated clients in their criminal proceedings, especially given that deportation was a likely outcome at the end, or certainly seemed to be the intended outcome by those enforcing these laws? Johnny, do you want to take a first crack?
Sure. We handled our first criminal case in August 2012, and this was after the GNC worksite raid. We knew that MCSO was engaged in racial profiling and discriminatory policing. Everybody did. But it was really the complicity of the county attorney and ICE that enabled Arpaio to cause so much harm in the community. Everyone arrested in these raids was held without bond under Proposition 100. And unless we were able to severely undermine the county's case, the only plea agreements that were extended were to offenses considered crimes involving moral turpitude. This happened because ICE trained the county attorney step by step how to fashion plea agreements and sentences to secure a non-citizen's removal. We knew in order to be effective, we had to engage the state and federal government both legally and politically. Before I go further, I want to amplify a little bit more what Lydia said about how these raids were conducted, because the legal violations were so pervasive and they happened at every stage. Each raid started with an anonymous tip. More often than not, the caller was complaining that the employer had hired undocumented workers, but MCSO never went after the employer. They would use that tip for quarterly tax and wage report that the employer had to file with the Arizona Department of Economic Security. These reports contain confidential tax information that is generally restricted from disclosure to law enforcement and should never have been provided to MCSO in the first place. MCSO would then take these reports and use the Social Security Administration's verification system to search literally hundreds of employees' names in Social Security numbers to identify which name and social didn't match. This too is a clear violation of Social Security Administration regulations. For people whose name and social didn't match, MCSO obtained a warrant. And on the day of the raid, criminal employment squad detectives would stop every Latino on the premises and question them for hours, even if their name was not in the warrant. Managers were used as Spanish language interpreters for their employees, who were subjected to coercive interrogations, and Miranda rights were rarely, if ever, read. On any given day, we could have dozens of people arrested. And for those undocumented workers that didn't actually commit a crime, couldn't be charged criminally by MCSO, they were still transferred to ICE, who initiated removal proceedings. So you can pick and choose what Fourth and Fifth Amendment violation you want to attack. It was still extremely difficult to convince a county judge to suppress evidence, especially given the political climate at that time. So one of the things we began doing that had not happened before in criminal cases is seek to dismiss the prosecution outright on the basis of federal preemption. Citing the Supreme Court's decisions in Chamber of Commerce versus Whiting, which dealt with the Legal Arizona Workers Act, and the SB 1070 case, we argue that the Immigration Reform and Control Act both expressly and impliedly preempted the state from prosecuting undocumented workers who sought to gain employment by providing information that didn't belong to them. Some judges began dismissing charges that were based on the Form I-9 and supporting documents like a Social Security card or a green card. But many times there were tax forms that the county was still allowed to charge and to proceed with. So we were getting good plea agreements for certain cases that we took up to the date of trial. But we knew that there were still people being harmed. So we started to search for alternative solutions, not only for our clients, but for everyone else that was being arrested during these raids. And in February 2013, we were lucky to broker meetings with folks from ICE headquarters in DC. And Delia can elaborate on that.
Yeah, because at a certain point, things changed.
Right. We knew that this was not only, we had to do criminal representation, we had to do immigration, policy, as well as political. And we had had this wonderful relationship with the Department of Justice, who had been in our office, and we had used them in securing plaintiffs for the lawsuits and reports on what was happening on the streets. And for us, we knew that at the end of the day, what our clients were willing to tolerate was to stay in Joe Arpaio's jails as long as they weren't going to get deported. And they wanted to stay here with their families. And we knew that the process by which they were conducting these raids was illegal. But at the same time, when they were transferred to ICE, ICE benefited from the opportunity to deport these individuals because many of them had class 4 felonies, class 6 felonies, were deemed crimes involving moral turpitude, and they were not eligible for bond at immigration and not eligible for relief to remain in the United States and to stay based on their children or spouses. So we went to ICE and we decided not to go local. We decided to use our relationships that we had built and talk to ICE headquarters. One night, we decided to have dinner at Durant's here in Phoenix. And we had dinner with the head of ICE. During that meeting, we brought him a memorandum and several cases, our cases, that were detained, women and men detained at the Eloy Detention Center. We explained that there was a conflict between the illegality of how the state, Arizona, was conducting these raids and doing criminal investigations when its own sister agency, the Department of Justice, was suing Joe Arpaio exactly for these violations. And that at the end of the day, they were benefiting from deporting these people, and there was a conflict of interest for one agency to use the deportation as a solid basis for removal and another to argue that they were illegal. They actually listened. And we also provided them evidence that it was the local ICE office of OCLA in Phoenix who had trained Maricopa County prosecutors on how to secure convictions that would land them in squarely within a removal proceeding and leave them no option to fight. That night was a pivotal moment for the movement, and it changed the course of the powerfulness that Arpaio and the raids had on undocumented people. So that happened in February of 2013 on a Wednesday. They flew back to DC, and we had given them a memorandum. We followed up with additional memorandums via email and silence. I went to the hearing in Eloy for my female client who had a Class 6 felony for identity theft. And I remember that the trial attorney came to me, and I was panicking because she was going to get deported that day. That was the final hearing, and she wasn't eligible for any benefit. And I remember the trial attorney coming and saying, "What did you do?" And I didn't know what he was referring to. But that day was the first day that a removal case with no relief was administratively closed, and she was allowed to go home that day and released by the immigration judge. I have to say that it was probably the highlight of our career to be able to do that. And we didn't just do that for our clients and her, but the policy was one that had to be implemented across the board to every undocumented person that came to the attention of the department, regardless if they were represented or
not. This is for both Johnny and Delia. Let's start with Delia. Please tell us about the role of activists, grassroots organizations, lawyers, media, and your clients. Tell how all these roles made things happen, and what were some of the benefits that the community got by fighting back against unconstitutional policing.
This is a question that I'd like you to chime in as well. This would have never happened without Lydia Guzman. And this would have never happened without activists being out there and living this nightmare and drawing attention to it under nightly news. And it would have never happened without the hotline. The hotline was pivotal in understanding not only what was happening, but the fear of what this community in Maricopa County and in Tucson were living. We found a niche for ourselves in this movement. And when we were doing this, it all sounds like we had a concerted effort to figure out, to know what we were doing. We weren't. We were doing this by the seat of our pants. What we knew, Johnny and I knew, was that what was happening was wrong. But we didn't know how to fix it because the power of Joe Arpaio and the political connection that this individual had in control over this community was massive. But it was the activists who broke that. And as Lydia said, changed that use the media to their advantage. The niche we found was to be activists in our own individual cases. We were lawyers and we didn't have a place in being visible in these protests, because if not, then we would gain no credibility from the department. And our role was to help our clients legally and to stay in the country. And in order to have an arm's length conversation with the department, we needed to be able to be credible as lawyers and credible for our clients. And so our niche and our place within this group of activists who did all the work, all the hard work, was for us to find a legal, political, and policy solution.
The activists, I think, especially Lydia Guzman and Carlos Garcia, were the two people that I got to work most with. They were often the first responders, and they were critical in connecting the members of the community organization to attorneys. Beyond the activists who were able to speak publicly, bring media attention to the problem, there was also a core group of attorneys that we worked with. In criminal court, Ray Nevada, Alex Navidad, and Antonio Bustamante also were advancing the preemption claims with us. And as those issues were litigated and they evolved, Danny Ortega was also fundamental in getting us meetings with Bill Montgomery. Bill Montgomery had a great deal of respect for Danny Ortega, and absent our connection to Danny, I don't think we would have been able to have meetings with Bill Montgomery to talk about how he fashioned his pleas to secure removal, how he allowed Joe Arpaio to continue to police in an unconstitutional manner because he turned around and then charged the crimes. So without a community effort, we wouldn't have been able to get as far as we did, and we wouldn't have had as many pathways that we walked down. And just from a media perspective, there were a lot of reporters that followed these issues, but we made the decision pretty early on to work with only a few. Jude was one of them, Stephen Lemons was another, and Valeria Fernandez. And we knew that we could trust them to speak to our clients and to understand what the legal issues are and to present them in a way that the public understood, but that also was powerful enough to get people in DC to understand that they needed to actually address what was happening in their culture.
They were extremely careful with the information that they got, and they always asked us whether the information was permissible release or how they should do it and when they should do it, because some of this was always a matter of timing. The only activists that we haven't talked about are the people who actually serve these prison and jail space. And for us, Luz changed our world. Luz was a client that was in custody for 9 months. And she had a child who had leukemia. And she didn't want to be deported because she needed to take care of this child. And, Danny Ortega brokered those meetings with Bill Montgomery, and she was always at the forefront. She spent 9 months in jail instead of taking 90 days, which was what the county offered, to be able to have a pathway forward. Today, Luz, and she showed us so much. She taught us, and she had the patience with us to learn the criminal, to get the legal arguments down, to present them. And these people who were rounded up like cows on these chain gangs, they really are the activists. And it was people like Lydia who informed these people that it was worth fighting and it was worth staying in custody to fight their cases. And had we not had that, we may not have been able to prevail because people were willing to stay in custody for the opportunity to stay. And today, Luz is a lawful permanent resident and on her way to become a citizen.
I'll just add one more thing to that, because I would be remiss not to mention them, but it was ultimately the ACLU and Irvine College of Law with Ray Vada that presented the federal preemption arguments in a federal class action lawsuit, Puente, Arizona, versus Arpaio. And as a result of that litigation, there's an injunction in place that still exists today, preventing the state from using the I-9 and supporting documents to charge undocumented workers for seeking to gain employment by providing false information.
Turning back now to Lydia. After collaborating with attorneys on these different lawsuits, Lydia, what advice do you have for young lawyers or future lawyers collaborating with activists? What makes collaborations between lawyers and activists work in your view? And what are some of the challenges?
You know, I believe that one of the things that I see a lot is when lawyers tell their clients not to participate in talking to activists. And I think that's hurtful because I understand that sometimes lawyers want to do the best job they can in representing their clients and obviously not saying something that it can be contradicted later on in testimony or in court, if they say it to the media. However, I think that there has to be a balance. And I think that in order for the way that I saw working with the lawyers that I worked with, in order for proper advocacy to take place, not just in the court, but the lawyers have to allow advocacy with their clients because there's something going on wrong and we need to change it also in the public, whether it's public perception, but we can't do it without the help of the victim of racial profiling or the worksite rate or we need them and we need the lawyers to allow that flexibility. What I can say is that the lawyers, they should work with the activists, work on the narrative, work with, many times the activists have the relationships with the media. And I think building those relationships is how we can help shape the narrative out in the public so that we can start looking at changing some of these policies. Not only is it taking place, the advocacy and the defense in the courtroom, but there's a lot of politics involved, and a lot of the politics revolves around public perception in the court of public perception. And so I think there has to be that balance. And I ask young lawyers when they encounter these types of cases where we know clearly that something is wrong and needs to be changed. It's one thing to defend your client and to represent your client, but also work with the advocacy groups to see how we can, build on this to change policy.
Thank you, Lydia. And so I want to close out now. We want your questions for the panel, but I'm going to just throw a question to everyone on the panel to close out, which is, we spent a great deal talking about the era between 2006 and 2013, 2014, where the Arpaio era, really, where he was doing so much immigration enforcement. And I want to bring that back to 2022. Like, what has changed on the ground in Arizona and Maricopa County? What hasn't? What is the risk of racial profiling by law enforcement agencies in Maricopa County against Latino drivers and passengers? Are traffic stops and other routine law enforcement still being used as a dragnet for deportation? And maybe, Delia, if you're able to weave into your comments, we had promised we were going to get to sort of where things stand with SB 1070 today. So maybe this is an opportunity to do that in yours. And then we want to open it up to everybody for our last 10 minutes or so.
I won't take up too much time. In 2016, Attorney General Brnovich agreed that it was going to be the policy in Arizona that no police officer would prolong a stop to secure immigration information or to secure that ICE arrive in the scene to detain the individual. So that is that was the settlement in section 2B of SB 1070. But that is an expanding and narrowing policy because it depends on who is in the White House, right? So when you have, when we had the prior administration, law enforcement agencies were continuing to regularly stop and detain individuals regardless of the length of time that a stop took. For instance, there's no reason to detain a passenger and refer them to ICE. Right? This is what's an example. And it continued to happen, not just by NCSO, but DPS and Phoenix Police. And sometimes it boils down to just one particular police officer. May not be the policy of the state, may not be the policy of the law enforcement agency, but it may be the policy or the intent of that particular police officer. So under the prior administration, we saw tremendous referrals, considerable referrals to ICE because the LEAs knew that the administration was removing individuals and placing them in removal. So there was that intended outcome, right? The arrest leads to getting the undocumented person in deportation proceedings. Under the Biden administration, we have seen less of that because they know that ICE is not detaining anyone and pretty much is not a priority under the current administration's guidelines. And so it's really not happening as much. So what happens at the top really affects what happens and is tolerated politically down below on the ground.
Okay, thank you. And sort of lightning round, because we want to get to audience questions. Johnny, do you have thoughts on what's changed and what hasn't?
I would agree with what Debbie said. I echo her sentiments. You know, I think politically, a lot of cities and towns, and also Maricopa County itself, feel as though they need to have ICE in the jails because if they take ICE away from the jails, then people who are arrested and charged with crimes, possibly convicted, won't be referred to ICE. And some of them use the SB 1070 agreement as a basis to keep ICE in the jail. But there's nothing that actually requires any of these facilities to have an ICE officer within them. And so, you know, that is one aspect of the political problem that has not changed. Also, you know, it's costly to litigate. And since 2016, we know that there have been consistent violations of the policy, more so during the Trump administration than now. But finding plaintiffs, getting attorneys who are willing to litigate this issue again in federal court to limit the scope and get more concrete guidelines is difficult, and it hasn't happened. And this is where Lydia Guzman is so important. People like Carlos Garcia before were so important in talking to the community, figuring out what themes there are during these stops, and then working with attorneys to present those issues.
And Lydia? Your thoughts on what's changed and what hasn't?
So let me tell you what hasn't changed is that the racial profiling stops continue to happen. Okay. But you know, the fact that we have a settlement agreement in Arizona, the door was really left open so that we can file another lawsuit on SB 1070. The fact of the matter is we really stopped looking for plaintiffs, but the stops continue to happen. As I'm talking to young attorneys, I think it's important for young attorneys and students that are going into the field of law to possibly expand the net. And I want to expand the net by saying, you know, we still have the ability to move SB 1070 off the books. Okay, that would be, and that is our goal ultimately, because this is nothing but an abuse, a tool that was used to weaponize against our community. And to this day, there still continue to be those little tools just like all of those laws that we talked about, those were nothing but tools to be utilized. And SB 1070, this remaining piece, that show me your papers piece, still remains on the books. But I think it's important to look for these cases. We can still, maybe reconnect with some of the attorneys that worked on cases like SB 1070, the Melandros case, ACLU, MALDEF, NILC. Some of these law firms are, would still be open to finding either that police agency or that, there's abuse of power still taking place. But I think it's important for us to keep our eyes open. It's still happening. Here's what has changed. In light of Ferguson, in light of the Floyd and Black Lives Matter and everything, there's more awareness to abuse. And there are now, with different police departments, they're putting in civilian, I guess, boards, advisory boards. These civilian advisory boards are a great tool to have, someone go in and maybe sit on these boards so that we can find ways to extract information, to share with the Department of Justice, to share with the community so that we can put a stop to this. And I think having these boards were meant to try to build bridges with the community, but I think the community needs to know that these are also ways to file complaints. And if complaints aren't being followed through, the Department of Justice has hired more people to look at more of these abuses. And I think that's just, some of the things that is revolving and taking place and escalating. So I just wanted to, go in that way. So.
Okay, great. Well, do we have some questions from the chat or from the room?
Yeah, so we have a question from the audience. You may have to repeat it because I'm not sure how much they
Should
can.
it be on mic? Is that on?
It is not on.
Can you turn it on?
Yes. Now it's on? That's it on.
I think it's on.
Okay. So the question from the audience is, could you speak to the legacy of the 2006 Arizona human smuggling law? It was struck down in 2013, but was it a building block for criminalizing immigration nationally more recently?
Do you guys want to grab that? I mean, I think one parallel that comes to mind that I think is an interesting case study to think about is just following what's happening in Texas with Governor Abbott's efforts to use a state trespassing law and use state law enforcement to arrest migrants on these trespassing charges. And we're seeing those cases. I think just in the last couple of weeks, there was a federal judge who called that policy unconstitutional. And I think there's things that are brewing there. And that will be interesting to watch, especially given that it's in the Fifth Circuit. And so, all these cases were happening in the Ninth Circuit that we've been talking about. But I'm guessing the Supreme Court ruling in Arizona over SB 1070 will probably play a faction in however that Texas situation plays out. But I think that to me seems like one of the best parallels to what Arpaio and Thomas tried in 2006 to the present. Any other thoughts?
No, I completely agree with you. I think that what's happening in Texas is a pretty clear parallel. I would also add, SB 1070 was enjoined before it ever actually started, but there were other states in the country that had the same law, essentially the same law, mirrored the same policy, and the enforcement was going to be used in the same way. And those were Kansas, South Carolina, Alabama. So for a long time, Arizona has been, the leader in fascist immigration enforcement, and other states do take our lead. And so that's why it was so important to challenge those laws here. And ultimately, the lawsuits did take time to play out. 7 years passed in between the beginning of the human smuggling law until we got the decision in Somos. But at the end of the day, we were able to prevail. And those arguments used in the Somos case were very similar to the arguments used in SB 1070 in Puente versus Arpaio. And so you have to combat them in the same manner and just be prepared for the same things to happen, because all this is really a wait. History shows us that, you know, there's ebbs and flows, and eventually states will want to, you know, attrition through enforcement, and we'll be prepared to do that.
Were there questions in the chat? No questions in the chat. Any comments that should be repeat in the chat that might be?
Well, unfortunately, I lost the first half of the chat, but I was monitoring it, so I don't think so. Laura Bachman notes that the link between decreased detention also means decreased money from the federal government for detention space, which gives less incentive to racially profile. And it's another reason why abuse of power nationally matters to local budgets and policies. So I don't know if any of you want to speak to that at all. Otherwise, lots of thank yous to all of you for being here and sharing. Yeah.
Well, we don't have time like for you to write it down, but we have about 1 minute left. If you came to the mic and said it, I think. Actually, 1 minute for Q and A.
Yeah. I was just wondering if and how any elements of the pandemic and vaccination mandates would impact the movement and your clients in these situations. There are in custody, there was a decision out of the state of California, Freyhad, that allowed the ICE to release individuals who are likely to get the virus and would have repercussions as a result of it. For example, diabetes or high blood pressure or obesity, or other underlying conditions. I think that COVID has distorted every aspect of detention work and our ability to get to some of our clients. Sometimes, for the most part, they have been released. I don't know if that answered your question.
Oh, I'm gonna officially close this out because I don't want to have anybody feel like they're captive beyond time. So if you're here and you need to leave, you should leave. And I just want to make sure to thank all of our panelists and speakers. This has been just fascinating. We could talk with you for another hour. And then if you guys do want to stay and continue a little more dialogue, that's okay with me. I just want to officially end and thank you guys all, and thank you everyone for attending.
Thank you for having us.
To answer that question.
Yeah.
Over, beginning in March 2020, I litigated a decent amount of COVID related detention claims. And it was only after there were lawsuits that I started releasing people who were high risk for negative outcomes, including death. Before that, the science was very clear that these facilities were tinderboxes to spread the virus, and that people who got sick in there were not going to get medical attention, because ICE doesn't provide medical attention. A lot of times these facilities are private, run by GEO or Core Civic. Their doctors don't provide the medical attention that was needed to actually help people who got sick. So it took about 4 to 5 months before we actually started seeing releases happen. There are still some facilities that are under injunctions to keep the capacity at a minimum so that people can social distance. They have to provide PPE, which did not exist in these facilities before. But as soon as those injunctions, run out, if they do and the pandemic's still ongoing, it will require another wave of litigation, because ICE and the private prison industry is not going to do this on their own. On a broader level, the government is using Title 42 to detain people at the border and then not allow them to claim asylum, which is an internationally recognized human right. But we've seen, for going more on more than 2 years now that people who come to the border to claim asylum are not given credible peer interviews. They're just summarily expelled. And so it's causing to be a buildup of people living at our southern border in conditions that are terrible. And we had the hope that the Biden administration would actually walk away from defending Title 42, but the opposite's happened. There's still defense of this policy. And, you know, the Biden administration, on a broader note, is still defending many lawsuits that we filed under Trump for like new regulations that did away with work permits for asylum seekers, or that, you know, made people have to wait longer in order to get a work permit when they're in removal proceedings. So while there has been policy-wise movement during the Biden administration, from a legal perspective, there's still a lot of the same issues that need to be litigated because Biden has not walked away.
The only thing I would add to that is that I think there'd be more litigation on COVID and releasing individuals if the Biden administration didn't have these priorities that didn't allow those people to come to be arrested. Thank you, Joy. To be arrested. So I think once there is a ramping up of detentions by ICE, I think that litigation will again come to fruition. Any other questions?
Okay.
Thank you. Thank you. Thank you for having us, and thank you to Jude, Lynn Marcus, Professor Marcus, and Terry Sterling for having us. And